Hello, my name is Ryan Craig. I'm a licensed building and timber pest consultant, and I'm the owner of the company QC's Building Services, carrying out inspections on residential properties in Brisbane for the last 20 years. This video is designed to provide purchasers with some information that is helpful in relation to any issues that may have been raised, defects or issues in the building inspection, and is contained within the building report, and just some advice as to how they should be aware of that may be beneficial to them during the negotiation period. Having said that, it's very, very important that it's understood by providing this video that there's a couple of things that are non-negotiable in terms of our role, the inspection company, in this area. One is that it's not the role of the consultant or an inspection company to get involved with any aspect of negotiation that may occur once our reports are given out to clients, if a purchaser decides to raise an issue with the seller. The only role that an inspector or consultant should play in relation to this area is by providing the information within the report in relation to timber pest matters and building defects to their client so that they can make an informed decision. A consultant should never ever suggest or proactively suggest that a client of theirs, a purchaser, should enter into any negotiation phase on any aspect of what is in their report, and also comment on any monetary figures that might be involved in terms of taking money off. It's not the role of a consultant or inspector to do that. It's really the sole decision of the purchaser and the client to decide as to what they choose to act on in terms of negotiation or not. And I just wanted to clarify that very specifically, and so that this video is not misled or is seen as me making it an encouragement for people to negotiate. It's not. It's if they do decide to negotiate, be aware of these things, as they will be helpful during that process. The video has been created because in the last 19 years, I beg your pardon, it's become very apparent that there is a lot of deceit and mistruths told in this area by particularly vendors and agents. So again, it's designed to empower the purchasers with examples of these and what to be aware of, so that they can approach the negotiation phase with confidence and with knowledge. It's, again, I know I'm being repetitive, but it's not designed to encourage you to negotiate. It's designed to advise of the rights and what mistruths there are if a purchaser decides to negotiate, so they're in a better position. That's clearly it. Alright, so what allows for a purchaser to enter into a negotiation with a seller? The standard contract used to buy a residential property allows for a building and pest inspection, and the building and pest inspection is to be carried out by a licensed company, and the purchaser is to receive written reports from that company. They are to be, in terms of the legal writing on the contract, satisfied with the outcome of those findings, or not satisfied, and they're to act reasonably. Now, if they are not satisfied and you want to pull out of the contract, the provision in the contract allows for that, because it says that if you're not satisfied you can pull out. You only have to act reasonably. This is the contract used to buy and sell properties, which is designed by the REIQ. Only issues in the building report can be used to be raised by a purchaser. You can't raise anything outside the building report during the negotiation phase. That's why it's critical for a purchaser to engage a company that exceeds the Australian standards and comments in areas that are not just the minimum requirement of the Australian standards, which is what most inspection companies do. You must engage someone that gives you more information than the minimum requirement in the Australian standards. If a purchaser decides not to pull out of a contract, but they're still not happy about some findings, they would like to enter into what is called negotiation, then that can be done, and it's up to the vendor and the purchaser to discuss these things and work out whether or not there's a resolution, and the purchase can carry on subject to certain things being acted on from the building report, and that's able to be negotiated by both the vendor and the purchaser. When is a purchaser allowed to negotiate? What is a purchaser allowed to negotiate with a vendor? Anything that is contained within a building report. There is no specifics as to you can use certain aspects of a building report or not. It says in the contract that basically any information within the building report is to be acted on you or by you, and you're to be reasonable and satisfied. Over the years, we've come across many agent and vendor claims that say that certain parts of a building inspection is not valid, or this is excluded because it's not in a building inspection report. It's a load of rubbish. The critical factor is that whatever company you engage to give you a building and pest inspection report, if you engage one to give you the minimum requirements and only adhere to the basics of the Australian standard, you won't get a lot of key information like air conditioning unit, information on air conditioning units, swimming pools, building certification, electrical fittings, whether or not they work. The list goes on and on. But if you engage a competent, thorough company that does comment in those areas and it's contained in the building report, it is certainly allowable for you to act on that information, because the contract that you sign says you're to be satisfied with the building report and be reasonable about that. It doesn't say anything about you can act on certain parts of the building report, so don't get hoodwinked by that common trick that's employed by often the vendors and the marketing agents. Nowhere ever in the building report, one thing that you need to do is ensure that conveyancing solicitors acting for purchasers, just on this note about what you can and can't act on, which is quite a critical issue, quite astoundingly, first of all, don't be manipulated by that. Understand your rights, and the contract allows you in section 4.1, all the clauses after that in the standard contract you sign will define what your rights are, and in that it says you have to get the building report and be satisfied and act reasonably. It doesn't say anything about specifics, so don't be manipulated by anyone telling you can or cannot act on that information in a building report because it's part of information contained in the Australian Standard for Building Inspections or whatever. That's completely irrelevant. Don't limit yourself to those kind of conditions and be making decisions with those kind of conditions, because it'll be to your detriment and potentially very costly. And again, the contract makes no reference to specifics of the Australian standard. It just says the building inspection report. Also, we've had over time, would you believe, some conveyancing solicitors acting for purchasers that will actually say this information, like you can't act on information within a building report in relation to building certification because it's not part of the Australian standard. Complete rubbish. I say again that it goes in relation to the contract you sign. It says you can act on the information within a building report. It says nothing about it being part of the Australian standard. So if you get a conveyancing solicitor acting for you, that's saying to you can't act on certain parts of the building report, I would respectfully suggest that you take that up with them and ask them why exactly that is, because of the terms in the contract that you've signed doesn't make any reference to you being able to act on certain parts of the building report or not act on certain parts of the building report. So don't accept it from your own conveyancing solicitor as well, because we've seen that on occasions as well. You can act on every single piece of information contained in the building report, whether it's excluded or part of the Australian standard, and that's your right. Okay, so make sure you get the ability to do that. A recommended course of action when you raise any issues to negotiate, what we would suggest you do based on what we've seen over the last 19 years, never ever enter into any verbal arrangements with the marketing agent or vendor about any issue you want to negotiate on. That can be fatalistic and often not acted on, and it leaves you powerless from a legal point of view. You've always got to ensure that any negotiations you enter into are formally documented in a written manner, preferably by your conveyancing solicitor, so you don't get into any disputes about what was verbally discussed and what was going to be done and not done. There are always risks with purchasers allowing vendors, when they're doing negotiation, to carry out rectifications for them on certain issues that have been raised, like building work. So be aware of this. If you are negotiating with a vendor and you want some particular issue rectified, it's a leaking shower or something like that, be aware that there are traps if you simply allow the vendor to do the work. A lot of purchasers seem to do this, but they don't seem to calculate the following, and that is, when vendors are allowed to do the work and do some sort of rectification on an issue and not followed up and closely monitored by the purchaser, it's almost always that the vendor will do the minimum amount of work available, not necessarily the best job, and it will be the least cost available, just putting a plaster on a cut that might need stitches is the analogy I use, because they are going to leave and they don't want to spend a lot of money. So you run that risk of a purchase if you allow that to happen. The other thing, if you allow vendors to carry out work on issues within a building report that you are having fixed as part of any negotiation, is that you will be legally left in the limbo probably if you have any warranties for that work that is done, and they will be done in the vendor's name, not in your name. So unless you make a specific arrangement for the warranty or the work to be done in your name as the purchaser but paid for by the vendor, then any warranty that might be applicable in the future, if you need to claim on it, you could run into problems, because the company that did the work will say simply, if you went to claim on a problem or a warranty, that you're not their client, the purchaser was their client, and the warranty wasn't transferable. So don't run the risk of missing out on any warranties if vendors do the work on certain issues raised by a building inspection. Because of this, it's always preferable, in our opinion, that a purchaser stays aware of what is being done for any rectification carried out by a vendor where that's agreed to be done, that you make sure that work is done to the best possible standard, not just the minimum cost, and any work done is transferred into your name, including warranties, so that you don't miss out on those kinds of things. As a summary, this is the most important thing. If you enter into negotiations, any information within a building report can be used for you to negotiate or act on, and you must not be or should not be told that that's otherwise, because there's no legal basis for it. And if you just refer to your contract, you will see in section 4.1 after that all the clauses that it doesn't say anything about what part of the building report you can use or act on. It says you can act on the building report globally. So that's the first thing. Never ever enter into negotiations with a vendor or an agent based on verbal commitments. Often they can get missed, denied, and basically you can be left with no legal protection if you do that. So always have them in a written and formal account of negotiation, and preferably done by your legal conveyancer, so that it's all dotted, the I's are dotted and the T's are crossed, and you're protected and things get done. Lastly, don't let vendors carry out repairs without you knowing what is done or having control of what is done, because often you get the lesser quality of work and you'll miss out on all the warranties and those kinds of things. So look, I hope this has been sort of beneficial for you in terms of if you are entering into a negotiation phase, and there are some critical aspects, as I've covered in this video, that purchasers don't seem to be aware of, that we often see them suffering for because of this as a result of carrying out our jobs. And I certainly hope this has helped you to better equip you if you do run into that situation where you do enter into negotiation. You can use some of this information based on our experiences. And so thank you for watching.